Good morning, good afternoon, good evening, depending on the time you're listening to this news from. This is breaking news. Reason why Nnamdi Kanu cannot be tired in Nigeria. He declares why Nnamdi Kanu will destroy Nigeria and Tinubu in particular if he is out of detention. IPOB lawyer Ejimakor. A lawyer Ejimakor, the special counsel to Nnamdi Kanu, the leader of the indigenous people of Biafra, IPOB, has explained why the Biafran agitator cannot be tried in any Nigerian court. Ejimakor explained that Nnamdi Kanu was illegally adopted in Kenya and subjected to extraordinary rendition in Nigeria. He noted that there was no evidence that the contents of Kenya's authority was obtained before charges were levied against Nnamdi Kanu. Recall that in June 2021, Nnamdi Kanu was arrested in Kenya and subjected to extraordinary rendition. Upon his return to Nigeria, the federal government arranged Nnamdi Kanu as a 4-count pre-rendition charges. The former Attorney General of the Nigerian, Abubakar Malami, withdrew all but one of the said 4-count charges and replaced them with 14-count charges bordering on terrorism and membership in a prescribed organization. In the course of time, the Federal High Court, pursuant to application made, reduced the charge to the 7 counts that were later quenched by the Court of Appeal, thus leading to the celebrated judgment charging Nnamdi Kanu and barring his trial in Nigeria. However, a statement issued by Ejimakor reads below: following his infamous extraordinary rendition, Nnamdi Kanu was on 29 June 2021 secretly arranged and without benefit of his counsel of record before the federal government courts, Abuja, on the 4 counts pre-rendition charges standing against him as of that date. The charge were treasonable felony, conspiracy to commit treasonable felony, illegal import of radio equipment, and also defamation of President Buhari in extradition practice. These charges was known as pre-extradition charges or pre-rendition charges, such as in this particular case. Subsequently, in a slew of amendments of charges, the then Attorney General of Nigeria, Abubakar Malami, withdrew all but one of the said 4-count charges and replaced them with an entirely new set of 14-count charges, and that all bordered on terrorism and membership in a prescribed organization. In the course of time, the Federal High Court, pursuant to applicant, made reduced the charges to 7-count charges that were later quenched by the Court of Appeal, thus leading to the celebrated judgment discharging Nnamdi Kanu and barring his trial in Nigeria. Without prejudice to any live judiciary proceedings currently pending and concerning Nnamdi Kanu, the public has a right to be informed of whether, after the rendition, it is legal for the Attorney General to abandon the extradition charges and array a whole new regime of charges against Nnamdi Kanu post-rendition. The simple answer is that it is illegal, and below are the reasons. Under the universally recognized doctrine known as the doctrine of the specialty, which pertains to extradition, a fugitive transferred from another country is subject to persecution only for those offenses for which he or she was transferred. But where his transfer failed, the monsters of the law of all constituted a reduction. He is not to be subjected to any trial or detention, but promptly returned to whence he was brought. This is a common law, and Nigerian recognized it and enacted it in Section 15 of Nigerian's Extradition Act, which provides as follows: to be sure that the foregoing provisions were as regards Nnamdi Kanu breached in all their material particular. First, as of 19 July 2021, when Nnamdi Kanu was adopted in Kenya, he was facing a 4-count charge, none of which included or bordered on terrorism or proscribed organization. Today, the charges have been expanded to 14-count charge in court, all of which virtually bordered on terrorism. This is a clear violation of the doctrine of specialty, especially in the view of the provision that a person falling without the Section 15 of Nigerian Extradition Act should not be detained or tried for any new offense without the prior consent of the countries surrendering him. This is also a double whammy because bringing up these new charges assumes he is subsequent upon the rendition and also tribal for the pre-existing charges, which is very wrong. Thank you, viewers, for listening to this news. You have heard it all from Ejimakor saying that telling us the reason why Nnamdi Kanu cannot be tried in Nigeria anymore. He's telling us the reason why Nnamdi Kanu was illegally adopted in Kenya and subjected to extraordinary rendition in Nigeria. He also noted that there was no evidence that the consent of Kenya authorities was obtained before charges were leveled against Nnamdi Kanu. So viewers, what is your take on this? Your comments concerning this news will be very much appreciated. Please don't hesitate to drop them down below the comment box. Click on